Am I a reasonable person? I guess I kind of feel like I have to be. I go to Harvard. I've always done well in school. I kind of have to be a reasonable person, don't I?
Am I a reasonable person?
I couldn't say.
Yeah, I mean, I would say that I'm a pretty reasonable person.
There are roughly 8 billion people alive today. Somewhere among them must be the reasonable person. But who is this reasonable person, and where can we find them? Legal scholars have written much on this topic. Justice Oliver Wendell Holmes believes that the reasonable person is the average man, the man of ordinary intelligence and prudence. But what does average mean? To answer this question, we'll dive back into history. The first traces of something resembling the reasonable person as a legal standard comes from the Hellenic Roman world. The Justinian civil code introduced bonus paterfamilias, or the good father. He was the paragon of a diligent and powerful man. Many Western European kingdoms and city-states, such as Italy, France, and Spain, adopted Justinian's concept into their civil codes. These good fathers became the predecessors of the modern reasonable person.
Bonus paterfamilias? No, I'm not a good father. I'm not any kind of father. So, I mean, no, I guess not. I guess I don't live up to that standard. I don't know.
During the end of the Enlightenment in 1804, the Napoleonic Civil Code introduced the standard of reasonable person, who was qualified with regard to age, sex, and condition of persons. In the common law tradition, the person of ordinary capacity first appears in 1703. To put this standard into the context of tort doctrine, we fast forward more than a century to Vaughan v. Menlove. In this case, Menlove constructed a haystack in his yard, which spontaneously ignited and burned down Vaughan's cottages. The court found, instead of saying that the liability for negligence should be coextensive with the judgment of each individual, which would be as variable as the length of the foot of each individual, we ought rather to adhere to the rule which requires in all cases a regard to caution such as a man of ordinary prudence would observe.
Man of ordinary prudence? I don't know much about ordinary prudence, but I haven't set my neighbor's house on fire yet.
The reasonable standard is prevalent in modern U.S. law, especially within tort doctrine. It is used to evaluate torts such as negligence, battery, false imprisonment, and defamation. The reasonable person is an objective standard. It does not take into account a person's race, sex, gender, class, or any other factors critical to personal identity. Despite its ostensible objectiveness, reasonableness is often defined by community norms. As Judge Learned Hand puts it, in most cases, reasonable prudence is in fact common prudence, but strictly speaking, it is never its measure. Common prudence is contextual and cultural, so the modern so-called objective standard in practice becomes, what does the court think an ordinary person would do in this situation? The reliance of the reasonable person test upon social norms led to various mounting critiques in the late 20th century. These critiques said that the patriarchal nature of the reasonable man standard was especially evident given its direct descent from various models of the legal good father. Critics were divided on solutions, however. Some suggested that the growing popularity of the reasonable person model was cause for optimism. In her 1993 article, Wendy Parker says that tort law, and the law of negligence in particular, has a role to play in shaping and changing attitudes and expectations. The process is well equipped to respond to a societal shift that demands not only gender-neutral language, but the measurable inclusiveness of women's perspectives that its use implies. This attitude suggests that the reasonable person standard, properly applied, can overcome patriarchal norms by including women's experiences and making legal standards gender-neutral. However, other critics were concerned that the reasonable person was merely a linguistic mask hiding the familiar face of the reasonable man, and that a more contextual standard was a better solution. In the 1993 case Radke v. Everett, a Michigan court said, "We believe that in a sexual harassment case involving a woman, the proper perspective to view the offensive conduct from is that of the reasonable woman, not that of the reasonable person." The Supreme Court of Michigan rejected this alternative, however, saying that the gender-conscious standard places undue emphasis on gender and the particular plaintiff, while it inappropriately de-emphasizes society's need for uniform standards of conduct.
I mean, I don't think that a reasonable person standard quite works, but I don't think that a reasonable woman standard quite works either. So it might be helpful for courts to move away from both of those things towards some new standard that I really don't know yet.
Genevieve Lloyd's 1984 book, The Man of Reason, Male and Female in Western Philosophy, argues that the genealogy of the concept of reasonableness itself is so deeply and inextricably tied up with maleness that reason itself has become a tool of patriarchal systems. These three critiques offer different challenges to the reasonable person standard, and each has been used to make similar arguments about other forms of discrimination and their relation to the reasonable person. No matter which critique, if any, you find compelling, the makeup of the current federal judiciary supports the claim that race and gender bias exist within the legal system. White men and women make up 75% of federal court judges. Men make up 63% of federal judges. This disparity is even more apparent at the intersection of race and gender, as women of color comprise only 7.5% of the federal judiciary. Although the reasonable person is not any one judge, who represents reasonableness if not judges? Could we say that, for this reason, the federal judiciary is reflective of a societal concept of reasonableness? Additionally, judges can only determine what reasonableness is by reference to their own experience and expertise. So maybe the reasonable person is a subjective standard after all, but one that resembles the judge rather than the defendant. Would a more diverse judiciary mitigate this issue? And how far can the reasonable person standard be refined before it becomes exactly the subjective and unpredictable test that the reasonable person standard sought to eliminate in the first place?
No? Yes? I don't know.
Yeah, I don't know.
I don't know. You tell me.